it is important that courts stir public confidence in bearing and determining cases across the board that cannot be effected if courts can commence cases and then abandon them at will on grounds of technicalities or excuses on grounds of coram non judice. In order to have a holistic perspective of the issue at hand, it is important to take into account several facts about this case. First, the accused persons were arraigned in court with these charges in 2016, July. Secondly, the matter began before another judge who had 2 witnesses before recusing herself due to the perceived length of the case that made it difficult to abandon her single judge station to attend to this matter. Thirdly, the court has taken 5 years to hear the case, hampered by many factors, and the most challenging being the COVID-19 pandemic that shut down courts for a considerable period. And fourthly, the court had a total of 46 witnesses for the prosecution, 7 witnesses in the trial within trial, and 19 defense witnesses. That makes a total of 72 witnesses. Fifthly, there were 11 lawyers in this case for the state, the defense, and the victims. Sixthly, there are over 6,700 handwritten notes of proceedings in 10 files in this matter, excluding documentary exhibits and submissions of counsel. Seventhly, this case had 3 witnesses under witness protection. Eighthly, the case involved a public interest issue of grave importance. Ninthly, one of the accused persons, that is the 5th accused, in this case is also under protection and was kept at Naivasha Maximum Prison when his co-accused were held at Community Maximum Prison. And lastly, there were 117 exhibits for the prosecution and 34 exhibits for the defense. Not to mention that if there is an interruption in the conclusion of the matter and the case is given to another judge to handle, there are several implications. First of all, the cost factor to the public offers will be enormous, considering but not limited to state officers who will be engaged in handling the matter. Second, the other important question to consider is what will be the effect or impact of handing over this file to another judge in the criminal division. If they will have to proceed to write judgment, how long will it take the judge to understand the numerous volumes of proceedings before penning down a judgment? And third, what guarantee will there be that witnesses will be found, supposing the matter were to be ordered to be tried afresh 7 years down the line? And fourth, what trauma will the families and colleagues of the deceased continue to suffer due to the prolonged waiting for the final determination of the case? And fifth, what of the accused persons having to have the case start all over again? Even the most strong and patient of them all will have trauma by such a move. I believe that it will be against public interest and public policy, and it will not serve efficacious disposal of this case to adjourn it and hand it over for continuation by another judge. Such an action does not settle well with the need to uphold the purpose, value, and principles of the Constitution, especially those touching on the expeditious delivery of justice without unreasonable delay, including advancing the rule of law, human rights, and good governance in exercise of its judicial authority as obligated under Article 259(2)(e) of the Constitution. Constitutional values, principles, and the rule of law and public interest will be best served by declining the invitation by counsel for the 5th accused to declare this court coram non judice. Now, the other issue was the identification of the bodies of the deceased persons and the post-mortem examination. The bodies of the deceased persons were identified to the pathologist, who was Dr. Odor Johansen, PW19. Now, PW19, the head of forensic medicine and chief government pathologist in the country, stated that on the 1st of July 2016, late in the afternoon, he was informed that there were bodies at City Mortuary that required post-mortem examination. He decided that there was need for X-ray and CT scans to be conducted on the body, since there was need to establish whether there were any fractures in the bodies which might be missed out during post-mortem. He asked for the bodies to undergo CT scans at Kenyatta National Hospital, and the same was conducted by Dr. P. Otieno, and the scans the report was part of what was exhibited. Now, PW19 stated that he conducted the post-mortem on the body of Willy Kimani on 4th of July 2016. He stated that he received the CT scan of the subject. The scan indicated that the subject had a fracture on the skull on the left side extending to the front side of the skull into the left eye socket bone. He also had a fracture on the right upper jaw and on the left cheekbone. He also had multiple skull and facial bone fractures. On post-mortem, PW19 stated that externally, the subject body had features of decomposition, including skin slipping. He stated that the body was distorted, swollen, was oozing from the mouth and the nose. He further stated that it had a laceration on the right side of the head, which was 2 centimeters long, and abrasions on the forehead. The left side of the head was deformed, and there was a contusion bruise on the back of the left head. He noted a deformation on the right side frontal parietal region of the head, which he explained as being a bash inside the head, indicative of a fracture underlying it. He indicated that there was a contusion on the back of the head, which was about 120 centimeters from the middle of the head, an abrasion of the right side of the head, an abrasion above the left eye, and an abrasion near the ear. He finally stated that there was an extensive bruise on the anterior wall. PW19 stated that internally the body of the deceased had signs of bleeding on the muscles of the chest, which were more on the right side. He stated that the lungs, the heart, the pancreas, the liver, and intestines and the spleen were decomposing. The abdomen had bruises on the internal right side. The stomach was empty, and the bruises were noted on the testicles. Now, he further stated that the head had hematoma of the scalp, fractures of the left head, of the left skull extending to the front, on the left eyeball and bone surrounding it, that on the right maxilla, upper jaw, and on the cheekbone there was a fracture. He stated that the subject's brain had liquefied because of decomposition and mixing with the blood. He concluded that the cause of death of the first deceased was due to head injury due to blunt force trauma. He described the bruising on the left forearm and the left elbow.
The second active person is feeling well. If that's if you can be able to sit down.
They can sit.
Sorry.
Is that the reason of the sound?
I think the microphone.
Okay, he described the bruising on the left forearm and left elbow as defensive injuries and produced the CT scan in respect of the first disease as Exhibit 29, his post-mortem form as Exhibit 29. The CT scan was Exhibit 29A and the post-mortem addendum as Exhibit 29B. PW19 explained that abrasions and scars could have been caused by a blunt object, while the contusions on the right temporal and cervicular region were caused by a blunt force trauma which caused bleeding under the skin. He stated that the defensive injuries were the ones he saw on the left forearm, and further explained that the injury to the head was very severe because of the extent of the fracture. He stated that it could have been caused by a drop of a stone or object on the head or a drop from a height. He stated that in his opinion, the immediate cause of death was the head injury due to its severity. PW19 stated that he conducted post-mortem of the third deceased on the 4th of July 2016 and that his CT scan revealed no fractures, no bullet holes and no cartridges, and his cartridges were normal. He stated that externally the third deceased body revealed features of decomposition including skin spillage, swelling and darkening of the skin. He stated that there was blood oozing from his nose and mouth. He further noted a bruise on the left cheek below the ear and a complete ligature mark and bruise around the neck. He stated that internally the third deceased body had a bruising on the surface of the thyroid bone cartilage. The hyoid bone was loose but not fractured and there was bleeding on the chest. He stated that the lungs, the heart, the intestines, the liver, the kidneys and the spleen were all decomposing. He further stated that there was a bruising on the scalp on the left and the back side. He stated that the brain was deluxified owing to its decomposition and mixing with blood. He further noted a bruise on the spine at the neck region area, hematoma, bruising of the left forearm from the wrist and on the left leg above the ankle and above the left knee. PW19 indicated that his conclusion was that the cause of death of the third deceased was ligature strangulation. He explained that the head injury was inflicted before the rope was tied to the neck. Therefore, the immediate cause of death was the ligature strangulation. He produced the post-mortem report, the CT scan and the post-mortem addendum, exhibit 30, 30A and 30B. Now, PW19 said that he conducted the post-mortem on the second deceased, on the body of the second deceased on the same day as the other two. He stated that the CT scan in respect of the second deceased revealed no fractures on the skeleton and no evidence of bullet entry was seen. PW19 stated that externally the body was decomposing and it had a bruise on the left eye, swelling above the left ear. He also noted an old scar on the inner aspect of the forearm and wrinkling of the foot, which he explained as being a sign of someone being removed from water. PW19 stated that internally the second deceased had hematoma on the thyroid cartilage, bruises on the left chest muscles with internal bleeding. He stated that the lungs, heart, pancreas, liver, kidneys and the spleen were all decomposing. He noted the bruises on the neck, the left ankle and left leg below the knee. He made the conclusion that the cause of death of the second deceased was injuries to the head, the neck and the chest. He explained that the hematoma on the thyroid cartilage was indicative of pressure applied to the neck. He further stated that the injury on the forearm was a healing scar. He produced a post-mortem in respect of the second deceased as exhibit 31, CT scan 31A, and the addendum to the post-mortem 31B. PW19 stated that he visited the scene where it was alleged the trio were murdered with an aim of looking for any biological exhibits, but he did not collect anything. He stated that all the injuries on the deceased person's bodies were inflicted when they were alive because one only bleeds when they are alive. In answer to a question put to him, PW19 testified that with the level of decomposition, it was difficult to see the ligature marks on the bodies. The issue of the cause of death or causation of death raised by Mr. MYKE is a challenge inter as to whether the fifth accused really knew how the deceased persons were murdered, as it is clear he did not himself either stand by to watch the deceased being murdered or participate in terms of strangling, hitings, assault or in any such cause injury to them. The fact is, by the time they ferried the deceased to River Athi, they were dead as a result of assault executed against them that night. In any event, in addition, the evidence of Dr. Johnson that due to composition, injuries may not have been easy to note. It is clear the deceased were battered by their tormentors. the level of the injuries is evidence of that. The first deceased, okay, I've already said the injuries which they had. So I say that I find no material variation between the confession by the fifth accused and the findings of the pathologist. Now, I must mention that the way to challenge the evidence of an expert, which includes a pathologist, is settled in law. Now, in cases including those that were cited by counsel, there is the Republic versus Landfair, a 1968 one All England report, which says that our view is that the evidence of a doctor, whether he be a police surgeon or anyone else, should be accepted unless the doctor himself shows that it ought not to be, as the evidence of a professional man giving independent expert evidence with the sole desire of assisting the court, and the famous one of Dali versus Republic, that it is now tried law that while the courts must give proper respect to the opinion of experts, such an experts are not, as it were, binding on the courts, and the courts must accept them. Such evidence must be considered along with other evidence available, and if there is a proper and cogent basis for rejecting the expert opinion, a court would be perfectly entitled to do so. There was no challenge to the findings of the pathologist on the postmortem examination of the deceased bodies. No question was put to Dr. Odor to explain his findings or expound on the basis of his findings. I appreciate that Mr. MYKE was not present when the pathologist testified. However, he had the right to recall him for further cross-examination when he came into the case, as he exercised in respect of the government chemist, Dr. Kimani. Now, having taken into consideration the findings by the pathologist and the circumstances under which the bodies were found, which I don't want to repeat, I find that the expert opinion of the pathologist was proper and cogent, and that there is no grounds not to accept his evidence. I'm satisfied that the prosecution case as to the cause of death was clear and confirms that the deceased persons were murdered. Now, whether the DNA analysis report by the government chemist should be rejected for non-compliance with sections 122A, B, C, and D of the Penal Code. Now, Dr. Kimani was PW 32, the government analyst. He told the court that on the 30th, they received exhibits and swaps, that is on 3 occasions, 13th of July, 15th of July and of 2016, and 29th of August 2016. Now, Mr. MYKE submitted that the right of the accused person was violated because the samples taken from him were illegally acquired evidence contrary to Article 50, Sub-Article 4 of the Constitution. He challenged the admission of Exhibit 72, the government chemist report, which included the results of the analysis of samples illegally taken from the fifth accused. Counsel relied on the provisions of sections 122A, B, C, D of the Penal Code and urged that PW 44 and 45, both officers below the rank of the inspectors, took the fifth accused for DNA sampling without an order of an inspector or above, and without the consent of the fifth accused, and also without a court order. Now, from the foregoing, I've quoted section 122A, A and C. So I say that from the foregoing provisions, a DNA sample can only be procured if a police officer from the rank of an inspector orders for it, or a court gives an order that the sample be procured from a suspect, or the subject himself consents to the giving of the samples. There is no doubt that PW 44 and 45 were, at the time the samples were taken from the fifth accused, of the ranks below that of inspector, empowered to take specimen in accordance with section 122A of the Penal Code. Their evidence was that they escorted the fifth accused on instructions from Chief Inspector Owino, but produced no written order authorizing the extraction of the samples from the fifth accused, as the law requires. Additionally, the evidence adduced by the prosecution is clear that no consent was obtained from the fifth accused in writing authorizing the extraction of the samples as required by law. That said, I find the objection raised by the fifth accused in this regard an academic exercise. This is because in his own defense, the fifth accused person placed himself at the scene of the lockers in Quo, where the exhibits for which DNA samples was required were recovered. The fifth accused admitted that he was at Soweto open fields at the time the deceased were murdered. He gave graphic detail of how he sat in the car, smoking, and how he threw the cigarette butts to the ground outside the car by opening the window slightly in order to do so. So having admitted that he was at the scene on the material time, that he discarded several cigarette butts there from where the police recovered them, that alone is an admission, and considering it against other evidence establishes without a doubt that he was at the scene of murder at the material time. Even without the samples taken from him, I find that there was sufficient evidence with which to find that the fifth accused was at the lockers in Quo in Soweto open field at the time the deceased were murdered. Now there is a historical background. So in this background, I will discuss how it all began. So the issue that degenerated into this case began with an encounter between the second deceased and the first accused. And regarding that, Mr. Ombeta, for the first and second accused person, urged that the evidence regarding the second arrest of the second deceased was contradictory. He took issue with the alleged arrest, urging it was not clear whether he was arrested near Mully's supermarket or outside his house. And secondly, Learned Counsel Mr. Ombeta urged that PW44, one of the key investigators of this case, agreed in his evidence that a police officer could arrest a person as many times as he is suspected to have committed an offense. I will consider the evidence adduced by the witnesses to determine these issues. So the very first encounter between the first accused and the second deceased was on the 10th of April 2015. The first accused and other officers were on duty near Mully's supermarket within Lolongo police station area, while the second deceased was engaged in his employment as a boda rider. It was during the evening hours. PW4, the wife of the second deceased, provided the information concerning this encounter as she was informed by her husband. Now PW35, the IPOA investigator, recorded a statement from the second deceased on the 27th of July 2015, outlining his complaint against the first accused on the basis of this first encounter, which is also consistent. Now PW5 and PW1 also received the information concerning this encounter from the second accused as well. So PW5 received it during an interview held between the 1st and the 6th of January 2016. PW1 handled the defense of the second accused, a second deceased, in court for the two cases against him, and got first-hand information. Now, before delving into the relationship between the first and the second first accused and the second deceased, let me mention that the first accused admitted that he shot the second deceased, but maintained that it was in defense of his colleague, a policewoman, and explained that the bullet hit the second deceased on the right wrist. I will come back to this later when considering the doctor's findings as per PWP3 form, which was Exhibit 76, to confirm the actual position. The first accused contended that the second deceased was about to attack his colleague, Corporal Jane Ngige, with a knife, and after warning him 3 times to put the knife down, he shot him. Now, PW35 was an investigator with IPOA. He testified that the second deceased made a complaint with IPOA on the 25th of July 2015 through an official IPOA complaint form, which was Exhibit 74. The complaint was handed over to him to deal, and he opened a complaint file. He testified that on 27th of July 2015, he invited the second deceased to his office, where he made a statement which PW35 reduced in writing, signed on every page by the second deceased. In brief, the statement was to the effect that the second deceased was shot by a policeman who was in company of a policewoman, that the policeman told the policewoman that he had shot the second deceased by mistake, that the policewoman told him to trump up charges against the second deceased to justify the shooting, that the policewoman gave him first aid, and after which he was taken with the vehicle registration number KBX 429G to Shalom Hospital. That after he was x-rayed at the hospital, he was locked up in the cells at Mlolongo Police Station from Friday to Monday with charges of being in possession of bangi and gambling in public. PW35 testified that he saw an injury on the right upper arm of the second deceased, but that he did not have a P3 form at the time, and he wrote in his statement that officers from Mlolongo refused to issue him with the form. PW35 testified that he personally went to see the OCS, Mlolongo Police Station, and told him that a P3 form should be issued to the second deceased, that it was issued on the 10th of September 2015 and completed by one Maureen Mudeo, a medical officer, on the 14th of September 2015. The P3 form was P Exhibit 76. It indicates that the second deceased had 4 scars of bullet injuries, an entry and exit bullet on the right upper arm, and 2 bullet wound scars, an entry wound on the lateral chest below the armpit, and an exit bullet wound on the posterior on the posterior chest. So the P3 form shows that the second deceased was shot on the right upper arm and the upper chest. The first accused evidence that he hit him on the right wrist is not supported by the doctor's findings. PW4 also made a mistake when she said that her husband, that is the second deceased, had injuries on the left lower hand. Now PW35 testified that on the 14th of March 2016, the second deceased went to see him accompanied by the first deceased, who left them alone. He said that the second deceased appeared to be in fear and told him that he had more information concerning further encounters with the police. Briefly, the second deceased lamented about an incident that had taken place on the 13th of December 2015, in which the first accused, the OCS Mlolongo's Chief Inspector Wambugu, and a policewoman, one Emily, took him from his home, blindfolded him, and threatened to kill him if he cooperated with the IPOA. That the same police officers were the ones present during the shooting incident. PW35 said that he recorded the statement of the second deceased as part of his investigations, and it was Exhibit 77. He testified that after receiving that report, he summoned and recorded statements from the first accused, one Corporal Jane Gige, one PC Philip Otuoma, and one PC Mwaniki on the 16th of March 2016. He stated that he informed the three that he was investigating an offense of assault, illegal wounding, misuse of firearm, and threat to kill. PW35 confirmed that he received on the 7th of April 2016 a letter, Exhibit 6, from the Witness Protection Agency. It was dated 1st of April 2016, and it was seeking to know whether the second deceased was their witness. He said that he learned from IJM that they had approached Witness Protection Agency to assist the second deceased case. To assist with the second deceased case, he said that he wrote back to them a letter which was dated 11th of May 2016, signed by the CEO, Elema Halake, which was Exhibit 78. In the letter, he confirmed that the second deceased was a witness of serious assault, annexing the statements of the deceased to the said letters. He said that he learned later that the second deceased died the same year. Now, PW1 stated that Mr. Willy Kimani, the first deceased, brought the case of Josephat Mwenda, the second deceased, to the organization's attention. He stated that that was in April 2015 and that it was in connection with the criminal case number 226 of 2015, that is Exhibit 1A and B, before the Principal Magistrates Court in Mavoko. The case referred to involved the second deceased, who had been shot accidentally by the first accused person using his private firearm in the process of being arrested and later charged with being in possession of narcotics. PW1, as the lead advocate, assessed the case and gave recommendations that it could succeed and that it had also met the organization's ideals of defending victims of injustice. He stated that he took over the case as the head advocate and he applied for the type proceedings of the criminal case on the 29th of June 2015 and was issued with the same, where he found that the second deceased had been charged with gambling in a field and being in possession of cannabis sativa. PW1 stated that on the 27th of December 2015, the second deceased gave a statement with the IJM recorded by the first deceased, in which he claimed that the now deceased OCS of Mlolongo had threatened him and warned him to withdraw the shooting complaint against the first accused with a power failure to which the first accused would kill him. That the very next day, he, that is the second deceased, was charged with the traffic offenses in traffic case number 1650 of 2015. He said that he looked at the merits of the case and recommended that the evidence seemed fabricated against the second deceased and that IJM should represent him. He said that the case was allocated to him to defend and that he made an oral application seeking to be supplied with the type proceedings of the traffic case which were provided. He stated that the criminal case number 226 of 2015 proceeded on the 16th of February 2016, which was the first date given for the hearing of the criminal case. It proceeded before Honorable Mumasaba in chambers. PW1 stated that the first accused hearing testified in cross-examination, which PW1 personally conducted, the first accused admitted shooting the second deceased using his private firearm while on police operation, that he confirmed taking the second deceased to a private hospital with his private vehicle, and that PW1 stated that the admissions are at page 14 of the proceedings of that day. He testified that the case was adjourned to 24th of April 2016, and that as they left court on the first floor after the matter was adjourned, himself and the three accused persons in the case, including the second deceased, were accosted by police officers who shoved them down the stairs. He said that the police officers informed him that they wanted to take the three accused persons so that they could help them in investigations of a crime that had been committed in Meru. PW1 stated that he insisted that any questions to his clients should be put to them in his presence, that as the officers escorted them to their vehicle outside Mavoko Court, they met with the first accused at the entrance of the court building, and that the first accused nodded at the police officers that had arrested them, who nodded back. PW1 stated that they were taken to Athi River CID offices, where they were kept waiting for about 45 minutes, after which Mr. Mudhe, one of the police officers, returned the identification cards of all the accused persons and let them go. PW1 stated that on the 29th of February 2016, they went back to the court in connection with the traffic case, and that he informed the court of the happenings of the 16th of February 2016, And he further stated that he had also written a letter to Inspector General of Police concerning the intimidation they had received on the said date. The letter was dated 24th of February 2016. Now, PW13 stated that PW13 was the director of casework at IJM, where he oversaw the day-to-day operations of the casework department, including the legal department, investigation, and aftercare departments. PW13 narrated the historical aspect of the second disease complaint and the steps IJM had taken to help him. Now, he stated that in the course of the hearings of the two cases against the second disease, he drafted letters to the Inspector General of Police and IPOA after PW1 and the second disease were arrested after a court session on the 16th of December 2016, 16th of February 2016. He produced the letter dated 24th of February 2016 addressed to the IG as exhibit number 3, in which he was asking for the suspension of the first accused in order to pave way for independent investigations into the allegations the second deceased herein had made against him. He also produced a letter dated 24th of February 2016 addressed to Witness Protection Agency as Exhibit 4, whereby he was requesting the agency to admit the second deceased into their program. PW13 stated that he received a letter from Witness Protection dated 1st of March 2016, which was Exhibit 5, which made reference to his letter of 24th of February. He further stated that he received a letter, Exhibit 6, dated 1st of April 2016, in which he was copied, and the main addressee was the CEO IPOA from Witness Protection, asking IPOA to confirm whether the second deceased was fit for witness protection. Now, I conclude that bit by saying that I find no contradiction in the accounts of the statement by the second deceased as narrated by the various witnesses. I find that the prosecution has established beyond any doubt that the second deceased was harassed by the first accused and his boss, the then OCS Mlolongo, Chief Inspector Wambogo, and other police officers, arresting him just outside his house in the second instant and charging him for offenses which he could not have committed, as all the witnesses, that is PW1, 4, and 5, among others, are all in agreement that he could no longer ride any motorcycle or do any work at the time. So I must end by saying that the second disease deserved action from IPOA and protection from Witness Protection, whose vehicles painfully ground too slowly, which proved fatal to the deceased. Now, the other issue is whether the prosecution has proved motive, and it is appropriate at this juncture to consider whether the prosecution proved motive, and the prosecution has set out facts to answer the issue whether there was any motive for the murder of this deceased persons in this case, the accused persons, any involvement with the murder of the deceased persons. Mr. Umbeta, for the first and second accused, urged that the second accused did not know any of the deceased persons, never met them, and could not have had any ill motive for any of them. As for the first accused, the learned counsel urged that there was no evidence the first accused had a motive to commit the murders. Mr. Umbeta urged that Exhibit 24, the investigation diary of the 27th of June 2016, a suspect, yet at the time no statement, no confession, and no data had been obtained. Learned counsel urged that the IJM and investigation team operated on suspicion without any evidence. Now, I have quoted Choge versus Republic on the issue of motive. The prosecution has adduced evidence to show the second deceased made complaints against the first deceased. The second deceased made complaints against the first accused of a shooting incident on the 10th of April 2015 in which he shot the second deceased. The second deceased made a second complaint against the first deceased for an unwarranted arrest and threat to kill made against the second deceased on the 13th of December 2015, at the same time when additional charges were preferred against him. Although he denies threat to kill the second deceased, the first accused does not deny the two incidents took place and that they culminated with the two cases filed against the second deceased person at Mavoko Law Courts. Indeed, in the criminal case, whose proceedings were Exhibit 1B, the first accused in cross-examination by PW1 admitted shooting the second deceased using his private firearm while on official duty. He also admitted driving the second deceased to a private hospital using his private vehicle and admitted that he locked him up in police cells a whole weekend, even though he was suffering severe bullet injuries inflicted by him. In addition, no police action was taken regarding the shooting incident. No spent cartridges collected as exhibits from the lockers in court, no P3 form issued to the victim, and no police file opened for the investigations. Not to mention the other ills of taking the victim to a private facility instead of a main hospital for specialized treatment, despite recommendation by the private doctors who saw the second disease at the river, considering the seriousness of the injury where a bullet hit the victim, piercing through the upper arm, and secondly, and significantly, piercing through the chest from the lateral to the posterior region. These were serious injuries. Indeed, the evidence of PW1, 4, and 5 were clear that the second deceased had not recovered from these injuries and could no longer perform any work 1 year after the shooting. Now, bearing these facts in mind, bearing in mind also that IJM had taken over the cases against the second deceased and were defending him in court, when the first accused and his colleagues were summoned by IPOA to give statements on the 16th of March 2016, it must have dawned on the first accused how serious the matter had become. I find that these facts cogently and firmly established that the first accused had developed a personal vendetta against the second deceased. I find that these facts establish that the first accused had a reason to silence the second deceased. His job was on the line, and actions towards realization of that fact were underway through IPOA. In regard to Mr. Mbeta's suspicion that there was, submissions that there was suspicion against his client even before any investigations had been carried out and before the bodies of the deceased had been found, he urged that the investigations were carried out to justify the arrest of the first accused. Counsel pointed fingers against PW5 of IJM as one who instigated that suspicion. That is not an accurate diagnosis. The evidence before the court shows clearly that the second deceased had filed a complaint against the first accused with IPOA, and that this agency did not take up the investigations immediately. When nothing seemed to happen is when the second deceased approached IJM for help, and this agency, that is IJM, acted more swiftly, even taking the second deceased out of his environment and offered him protection and legal and psychosocial support for 6 months before he was murdered. IJM had a clearer picture of the second deceased dilemma and had a lot of first-hand information regarding the experiences of the second deceased at the hands of the police. And from that standpoint, whatever PW5 said about the case was reasonable. In regard to motive, I find that the threat to loss of his employment was serious enough to have caused the first accused person anxiety and must have driven him to plan the attack on the second deceased. Of all the accused persons in this case, the first accused is the only person charged in this case who had a motive to harm the second deceased. The harm to the first and the third deceased was collateral damage just because they happened to have been there when the second deceased was kidnapped. I find that even though it is not a requirement for it to be proved, the prosecution accused has any probative value, So before I consider this issue of the probative value of the statement and the inquiry taken from the fifth accused, it is expedient to give a summary of the statement. Now, in his confession, the fifth accused gave his phone number, contacts, that is 0727-433-431 and 0795845584. He stated that he resided within Waithaka and that he was a police informer and that he was recruited by the OCS Lele, who was PW20 in the case, in April 2011, who was at the time based in Kabete. The fifth accused stated that sometimes in April 2016, he went to Mlolongo police station to meet PW20 after he learned that he had been transferred to Mlolongo. He said that PW20 introduced him to 3 police officers in the SPIV team. He stated that he visited Mlolongo police station on several occasions after that and became acquainted with the first accused, that sometimes in early May 2016, the first accused approached him and informed him that a thug that he had shot and injured wanted him to lose his job, that in the last week of May 2016, he stated that the first accused called him on phone and that they met at Connections Bar in Mlolongo, where the first accused told him that there was someone who had reported him to IPOA and that his case was coming up on the 23rd of June 2016 and that they must act on that day. He stated that on the 22nd of June 2016, he met the first accused at the police canteen at Mlolongo police station, where the first accused told him that he wanted him to follow the subject person after his court case and update him, that is the first accused, on all his movements. The first accused gave him a mobile number to use, but he could not recall the phone number. That on the material day, that is on the 23rd of June 2016, he left his house at 5:30, arrived at Mlolongo at 7:30. On his way to the Mlolongo police station, he met the first accused, who was driving a white Nissan Wing Road, registration number KBF. That the first accused introduced the lady as the person who would assist him identify the subject person. He stated that the first accused dropped him at a bus stop at Mlolongo, where they would board a matatu that would take them to Mavoko Locals. That at Mavoko Locals at around 9 a.m., the lady identified the subject person to him from a distance of about 5 to 6 meters. He stated that she told him, in quotes, "Kamutu yako ndio hiyo." The lady then left immediately. The fifth accused narrated how he communicated with the first accused, the arrival of the second deceased to court, his movements up until 11 a.m. when the second deceased came out of the courtroom. The fifth accused stated that he called the first accused and informed him that the subject person had left the courtroom but was accompanied by another man and had entered a vehicle that was parked in the court premises and sat in the rear passenger seat. The fifth accused stated that he went outside the court premises to where the first accused had parked his car and entered the rear passenger seat, while the first accused was the driver and Sergeant Mwangi sat at the co-driver's seat. He stated that he knew Sergeant Mwangi because he worked with the first accused, and that the first accused had told him that Sergeant Mwangi was part of the operation plan. They waited a few minutes, after which the vehicle where the subject person had entered drove past them with 3 occupants. That they followed the vehicle and caught up with it at the railway crossing. He stated that Sergeant Mwangi drew his police pocket phone and beckoned them to stop. Sergeant Mwangi told the 3 occupants that they were under arrest. The 3 occupants alighted from their vehicle and entered the first accused vehicle. The fifth accused stated that he took over their vehicle and drove it to Kwambira, where he abandoned it. He stated that the 3 deceased persons were taken to Syokimau AP post. That after he dumped the vehicle, he called the first accused, who told him to find them at Mlolongo. The fifth accused stated that he linked up with the first accused and Sergeant Mwangi at Connections Bar in Mlolongo. At about 7 p.m., the first accused received a call from someone at Syokimau AP post, who informed him that one of the victims had contacted his wife, that the first accused called an officer known as Kamenjo and asked him to make his way to the Syokimau police post, where he, the fifth accused, first accused and Sergeant Mwangi also proceeded and found Kamenjo already at the post waiting for them. The fifth accused stated that the first accused went inside a room, took the keys to the cells, opened the cell, and ordered the three victims to enter his vehicle, that is the wing road, that the Sergeant Mwangi handcuffed them while they were in the boot of the car, that he and Sergeant Mwangi entered the vehicle of the first accused, and the first accused drove, with Kamenjo following behind them closely in his car, a Toyota NZD, registration number KBU. The fifth accused stated that they drove to an area a few meters away from the highway, where they discussed whether or not to kill the three victims for close to 3 hours. That at about 9 p.m., a police officer who was driving a pro box passed by and asked them to identify themselves. He stated that Kamenjo, who also had a police pocket phone, told the officer that there were police officers on duty. The fifth accused stated that at about 10 p.m., the second deceased was killed. He stated that he was strangled to death using a rope and a nylon paper. His body was put in a sack and put in the boot of the Toyota NZE. And at this time, the police officer who had earlier asked them to identify themselves passed by again on his way home. He was driving a pro box and he waved at them as he drove by. The fifth accused stated that at about 11 p.m., the second victim was removed from the boot of the wing road, taken to a different ground, not the same place the second deceased was killed. He stated that the second victim was killed in the same style as the second deceased. His body was put in two sacks as he was tall and could not fit into one sack. The two sacks were joined at the hip with a rope. His body was also put in the Toyota NZD. The third victim was also killed in the same style as the other two. His body was put in a sack and placed in the boot of the wing road. The body of the first victim, that is the second deceased, was transferred from the Toyota NZD to the wing road. So the fifth accused stated that his role in this case was to look out and remove the victims from the wing road, hand them over to the Sergeant Mwangi, who in turn escorted the victims to the first accused and Kamenjo, where they were executed, where the execution took place. The fifth accused stated that after all the victims had died, he drove the wing road, which had two bodies, accompanied by the first accused, that Kamenjo drove his Toyota NZD, which had one body and was accompanied by Sergeant Mwangi. He stated that they drove to Mombasa-Nairobi Highway towards Cabanas, joined the northern bypass, drove through Roiro, Thika, Makongeni area up to Oldonyo Sapuk, where they stopped by a bridge. The body that was in the Toyota NZE was removed by Sergeant Mwangi and Kamenjo and thrown into the river. The two remaining bodies were removed from the wing road by the first accused and Sergeant Mwangi and also thrown into the river. They all drove back using the same route and arrived at Mlolongo at about 4 a.m. The fifth accused stated that they all went to a pub near an Asian restaurant where they got supper, that the first accused left them at about 4:30 a.m. while Sergeant Mwangi left a few minutes later, that Kamenjo left much later at about 6 a.m. For him, the fifth accused stated that he slept at the bar as he had taken too much to drink. Now, Mr. MYKE urged the court to consider that the fifth accused was arrested on the 8th of August 2016 at 8 p.m. but was not booked in any police station until the next day, and he urged that the fifth accused was taken to flying squad offices, then the DCI headquarters, where the statement was recorded. Now, Mr. MYKE, for the fifth accused, urged the court to reconsider the admission of the retracted confession of the fifth accused, admitted as Exhibit 90. He quoted several cases for that proposition. He urged the court to weigh the confession and satisfy itself whether it can rely on it given the retraction by the fifth accused, and also quoted more authorities on that. Now, Mr. MYKE also submitted that the retracted confessions fails the test that was laid out in Kapepere case, Supra, as nothing shows, outside of it shows that it was true, since it was uncorroborated by the facts, and secondly, the statement contained therein was not based on fact, as they could neither be ascertained nor proved. Now, regarding the circumstances surrounding the arrest, recording of the confession statement, detention up to until his arraignment before the court was indicative of physical, that is the submission of Mr. MYKE, physical, mental, and psychological torture, and that for that reason the confession should not be relied on. The learned counsel, Mr. Mutuku, submitted that through the testimony of PW 38, PW 44, and 45, the confession statement was recorded voluntarily by the fifth accused person, and its compliance with the evidence out of court confessions rules 2009. He urged the court not to review its ruling delivered on the 9th of May 2019 in that regard. Now, Mr. Ombeta, for the first and the second accused, also made submissions regarding the confession, and he urged that the fifth accused, in his defense in court, said that his confession was a result of inducement and or incentive, that he would be paid 30,000 per month, and that his wife would be given 200,000 to relocate her business. Counsel urged that the fifth accused was treated well while in custody because he agreed to implicate the first accused. He urged the court to note that the fifth accused in his defense, in his oral evidence, said that he saw the first accused once giving petrol money to Soweto at Soweto open field area at 10:15 p.m. on the 23rd of June 2016, that he saw him again on the 24th at his bar. Mr. Ombeta urged that the court to find that the first accused has shown that he was home at 10:15 p.m. on the 23rd of June 2016. Mr. Keegan, for the third accused, urged that the evidence adduced by the prosecution in the retracted confession of the fifth accused person did not implicate the third accused in any way. Mr. Muchere, for the fourth accused, urged that the retracted statement of the fifth accused places the fourth accused after the arrest of the fourth accused, which was deliberately written to book the fourth accused into the offense by co-joining him with the first accused, who he deputized at work. He urged that the confession fails to fix the fourth accused, as he gave account of where he was in his statement that was produced in court, and taken from him on the 4th of July 2016. Council urged that his mobile data exhibit 98B placed him away from the scenes of murder. I have considered the rival submissions of defense counsels and the state. The fifth accused had earlier at the trial moved this court by way of a notice of motion dated 7th of August 2019, seeking the court to review its earlier ruling admitting the retracted confession of the fifth accused in this court's ruling of the 16th of May 2019. Secondly, he sought the court to issue any order it deemed necessary. At the time, Mr. MYKE's grounds for the application were that confessions were generally inadmissible in this jurisdiction, that the court erred in finding that the provisions of Section 6 of the Evidence Act applied to the question of admissibility of the statement of confession, that out-of-court confessions and all ancillary provisions of law were outlawed and repealed, respectively, by Section 99 of the Criminal Law Amendment Act 2003, and that the evidence out-of-court confession rules have no force of law. This court considered the issue of admissibility or otherwise of the statement by the fifth accused and made a ruling on it after testing whether the statement was recorded in compliance to the relevant provisions of the Evidence Act and the Evidence Out-of-Court Confessions Rules 2009 through a trial within a trial, and also whether he made it voluntarily. This court had dismissed the application for reason that although it was clothed as an application for review, it was for all purposes an appeal against the ruling of the court. The application was urging the court to find that it erred in interpretation of the relevant law, effectively urging the court to sit on appeal on its own decision. So this court cannot review or reconsider the admissibility of the statement. What the court can do is consider the entire evidence and weigh it for two things. One, whether there is independent evidence which would lead to a conclusion that what the fifth accused stated in his retracted statement must be true, and two, when consider whether there is evidence of some material particular which implicates the fifth accused and establishes that he is guilty of the offense. So before I consider the probative value of the retracted confession, I wish to draw a distinction between a repudiated and a retracted confession. In the case of Ongero Omurwa versus Republic, the court has discussed in detail whether there is any real distinction between these two, and quoted in extenso and with approval the observations that were made by the Court of Appeal of East Africa in that regard in the famous decision of Tuamoy versus Uganda, where the court said that we now come to the distinction that has been made over the years between a statement retracted and a statement repudiated. The basic difference is, of course, that a retracted statement occurs when the accused person admits that he made the statement recorded but now seeks to recant, to take back what he said, generally on the ground that he had been forced or induced to make the statement. In other words, that the statement was not a voluntary one. On the other hand, a repudiated statement is one which the accused person avers that he never made. Now, a repudiated statement is one which the accused person denies making. A retracted confession is a statement made by an accused person before the trial begins, by which he admits to have committed the offense, but which he disowns at the trial. And confession is said to be retracted only where the accused person admits that he made the confession and then denies the truth either in part or whole, or to what is stated therein. So the statement of the fifth accused, Exhibit 90, falls under this category, that the fifth accused person admitted he made the statement to the police but denies portions of what is stated therein, and has gone further through his own defense, varied portions of that confession. So the correct test to apply in order to determine the probative value of a retracted confession was discussed by the Court of Appeal in the case of Vijay Kumar which I have quoted. Maybe I can just read a portion. The learned judge was obviously satisfied that the confessions were the truth of what occurred that night, but did not act on them alone. He accepted them with a caution, realizing they were both retracted and repudiated, and he was careful to look for corroboration of each one. This was, no doubt, in accordance with the principles set out into MYKE versus Uganda. Now, there are many other cases I've quoted, which I do not want to go into. So these are the guiding principles of testing a retracted confession in order to determine its value. So the first step to take is to consider whether the retracted statement is the truth of what happened. The statement under inquiry made by the fifth accused is a clear admission of his guilt, and he stated that as much on oath as he sought to qualify his confession with oral evidence, that he was not denying that he was involved in the murders of the deceased person, but wanted to show that his role was not as stated in the confession. Now, in the retracted confession, the fifth accused goes into detail and describes how the plot to kill the second deceased person was hatched and planned, days to the material day of the murder, naming the perpetrator as the first accused, giving the reason for the first accused's desire to do so as the threat to his job due to a report of misuse of firearm and unlawful wounding that the second deceased had filed against him with IPOA, which agency was on his back. He gives the names of the others involved by what appears to be nicknames, but describes some of them like Kamau and Sergeant Mwangi of SPIF team. He then went into great details of the trail on the deceased persons on the 23rd of June 2016 from Mavoko Law Courts, where they attended a trial against the second deceased, the rail crossing behind Mavoko where the three were kidnapped, and their vehicle given to the fifth accused who disposed it in Kamerudu, their holding at the post, their removal to Soweto open field where they were murdered, and the journey by road in two vehicles to Kilimambago, Oldonyo Sapu, where their bodies were hurled into the river Athi, and the celebration sponsored by the first accused and his wife, defense witness number 16, for the completion of the assignment. I have considered the evidence adduced by the witnesses in this case, the forensic and other evidence, to find out if there is any convergence with the retracted confession of the fifth accused. The fifth accused testified that he was introduced to the first accused by the OCS, Chief Inspector Lelei, PW20, in April 2016. Now, PW20 admitted that the fifth accused went to greet him at the Mlolongo police station around the alleged time, soon after he had been transferred there, having worked with him as his informer previously in a different station. That explains how the fifth accused visited Mlolongo police station in the first place, making the evidence that he got to know the first accused among others at the police station not a remote one at all. Now, before I state what I need to state here, it should be noted that P Exhibit 90, that is the retracted confession, was recorded on the 9th of August 2016, while the trajectory evidence on the phone, vehicle, plate identification, and police radio phone data had not been availed. The data was availed as from the 14th of October 2016. This then means that timings and sites in the retracted confession, Exhibit 90, was from the fifth accused's own knowledge and memory. The variation I noted between the fifth accused's retracted confession and the data of his phone, which was Exhibit 105B, was minimal, being a difference of few hours, and did not materially affect the statement. I sought for corroboration in the evidence of witnesses and other forensic evidence as part not only of testing the retracted confession, but also as part of exercising caution and careful consideration of the same. The statement shows the movements made by the perpetrators of these murders from the kidnap outside Mavoko locals, pressings at around 11, to the journey to the post, to the removal of the deceased persons just after 7 p.m., the journey to Soweto open field, and eventual trip to Oldonyo Sapuk in the Kilimambogo where the bodies were disposed of. These movements were captured in the data of the fifth accused phone, which is Exhibit 105B, and to give a detailed summary, so the data shows that the fifth accused line 0727433431 on the 23rd of June 2016 was at Mlolongo Police Station at 9:17 hours. He was at Esa Adriva 9:43 a.m. to 11:45 a.m. At Adriva at 12:02, at Cameredo 2 p.m. to 2:43 p.m. at Center Mombasa Road at 18:30 hours, at Mastermind from 21:17 hours to 21:24 hours, on Thika Road on the way to Thika Town at 00:47 hours, that is on the 24th of June, the same night, at Kilimambogo at 1:27 a.m. to 1:23 to 1:27 a.m., at Mlolongo at 6:02 a.m. to 2:53 p.m. Now, PW36 testified that the police pocket phone, IMEA number 8641060-200-19873, which was Exhibit 25, on the 23rd of June 2017, the said pocket phone was captured in various sites of interest as per its data, which was Exhibit 79. It was located at Mavoko locals at between 12 and 12:20 hours, at Syokimau AP post between 12:20 and 12:40 hours, at Mombasa Road between 13:40 and 14:40, at Mlolongo Police Station 15:20 to 15:40, between 18:40 to 1900 hours, it was at Syokimau AP post. Then between 1900 to 1920 hours, it was captured along Mombasa Road. At 1940 hours, it was at the isolated area in Soweto, where it was stationary for 5 hours. At about midnight, the pocket phone was sighted at the southern bypass on the way to Thika Road. PW36 stated that the radio in question was recovered from the first accused when he was arrested on the 1st of July 2016. That trajectory of the phone, which was Exhibit 79, is in tandem with the retracted confession of the fifth accused in every respect. It shows that the first accused was present in those sites as shown herein above, as the fifth accused stated in the retracted confession. Now, the other evidence which speaks to what is contained in the confession of the fifth accused is the evidence of PW 10, 11, and 12, residents of Soweto isolated area. From their evidence, they confirm sighting one, then later two vehicles parked within the vast isolated area. Their evidence confirms that the persons they saw standing around the vehicles were 4. They saw one with a police phone and one smoking a cigarette, that they remained in that area from around 7 p.m. way past 11 p.m. that night, that they identified themselves as police officers, and all these details were in tandem with the confession by the fifth accused. The retrieval of the bodies of the deceased on the 30th of June and 1st of July 2016 from the River Adi, 7 days after the murder in respect of the first and third deceased, and 8 days in respect of the second deceased, all confirmed the retracted confession of the fifth accused that he was telling the truth concerning the entire process. The postmortem findings confirmed that the fifth accused said that the deceased were murdered. Now, the evidence on the data that is Exhibit 79, which was from the radio, Exhibit 25, The evidence on the note, Exhibit 10, the note, I think was Exhibit 7, the evidence of PW 10, 11, and 12, the evidence of PW 20, the OCS, and the evidence of the retrieval of the bodies of the deceased from the river Athi comprises of independent evidence. That evidence was consistent with the retracted confession of the fifth accused and confirms that what was stated in the confession was the truth. Furthermore, the note Exhibit 7 collected outside the container used as a cell at the post bearing the handwritings of the first deceased are proof beyond any reasonable doubt that the first deceased had been taken to the post on the 23rd of June 2016 in the afternoon, as the fifth accused stated. The other evidence was the vehicle KBX 126C, which ferried the deceased to the Mavoko locals, which was recovered in Kameredu, just as described by the fifth accused. The fifth accused DNA from the cigarette butts recovered at the Soweto open field where the murders took place. I have carefully considered the retracted confession and the other evidence, as well as I cautioned myself of the danger of relying on the retracted confession of the fifth accused, Exhibit 90, having considered all the circumstances of the case and bearing in mind the independent evidence as enumerated herein above, which I found to be consistent with the retracted confession of the fifth accused. I'm satisfied that the fifth accused stated what the fifth accused stated in his retracted evidence was the truth and details what happened in this case. The retracted confession stated clearly the plot and the plan to murder, the different roles played by the various actors, to ensure seamless execution of their plan and murder of the deceased and the disposal of the bodies of the deceased 100 kilometers or more from the scene of murder. I am satisfied that taking all the evidence and the surrounding circumstances of the case into consideration, that there is no reason to believe that the retracted confession by the fifth accused is not, sorry. I'm satisfied taking all the evidence and the surrounding circumstances of the case into consideration that there is no reason to believe the retracted confession by the fifth accused is not the truth of how the deceased met their death on the material day. I must at this juncture set out the fifth accused's own statement in his defense in court, the difference between the sworn defense and the retracted confession. In his own defense, the fifth accused maintains the structure of his story in the retracted confession, but drops some names and brings in new names into the conspiracy of the murders and the execution of the deceased persons, as well as varies the role he played in the murders. He stated that when he realized that PW 20 Chief Inspector Lelei was in Mlolongo Police Station, he started going there to sell jeans, which is what he did for a living, that he did so on the 22nd of June 2016, and that on the 23rd June 2016, very early in the morning, he received a call from PW 26, PC Wilson Kamau, asking him to report to Mlolongo Police Station that morning, which he did and was there by 8:30 a.m. He said that he found PW6 with one Waingo and one Kamenjo, both police officers, that PW26 told him that there was a Kamwizi, a thief, that he was due to go to court for his trial that same day, and that he wanted to eliminate him, and that his role, that is the role of the fifth accused, was to keep track of the man and keep reporting to Kamau. That at the same time, PW26 gave him a phone number to use while calling him, saying his had gone off, and of that number, he could only recall 0786. He also changed the story, saying it was PW26 who called him to describe how the man he was to track was dressed. The other variation he makes in his sworn defense is that the Toyota NZE was with one Brown and not Kamenjo, as he had stated in his confession. Kamenjo was also there, and that he was the one who handed over to him the vehicle that the deceased left the court in. He varies his story, saying that he was directed by PW26 to take the vehicle of the deceased person and a small walkie-talkie to a police officer in at Kamerudo in Limuru. He also changes his involvement, saying that he was left at a bar when PW6, Kamenjo, Waingo, and Brown went away with one MYKE, a police officer, to the post where the deceased were held. He said that Waingo found him at the bar at 9 p.m. and told him where to go to find PW26. That was the Soweto area. He gives the names of those he met at Soweto, open field, as PW26, Kamenjo, and Brown, who were standing together, while a distance away stood MYKE and Wawero. Then Waingo joined them at 10. He gives the role he played as that of sitting inside the vehicle and driving one of the two cars. He also said that before they drove to Thika from that scene, the first accused brought money to PW26 to fuel the vehicle. He, that is PW26, was driving, as it was a station vehicle. The other detail he added was that after their return from Thika and the bridge at Oldonyo Sapuk, where they dumped the bodies, Leliman came to the bar where he, Kamenjo, and Brown were waiting for others, and brought them 5 kilos of roast meat and 5 bottles of beer each to enjoy. He said that the bar belonged to the first accused and that the wife of the first accused was the cashier. Now, the name that was dropped in the fifth accused's own defense was that of Sergeant Mwangi, the fourth accused in this case. The confession had mentioned PW26. However, in his own defense, the fifth accused said that PW26 was the mastermind of the execution of the deceased and that he was the one who approached him for his assistance in the plot to murder the deceased. The fifth accused added new names, Mr. Brown, Waingo, and MYKE. He also decanted the role of the first accused from being the mastermind and planner of the murders to being a facilitator and an entertainer. Now, having considered the confession and the sworn defense, I find that the structure and the main features of the information the fifth accused gave in both these statements remained intact, and therefore it does not make any material difference or create any doubt as to the fact the incidents discussed in the statements took place. Now, both the retracted statement, Exhibit 90, and the sworn defense qualify as a confession, and this is because, based on the confessions without other evidence, there is sufficient evidence to sustain a conviction against the fifth accused. As to the probative value of the confessions, of the confession Exhibit 90, on the co-accused, I will discuss it here in subsequent paragraphs. Now, I've also discussed the lock-in co. The prosecution had built up its case around 5 scenes. The lock-in co that featured prominently in the evidence of the witnesses in the case. In addition to these scenes, it emerged that there were underlying factors that formed in an integral way the background events that were the catalyst to the sequence of the events of 23rd of June 2016, leading up to the murder of the deceased. I have herein above dealt with some of the underlying factors. I will deal with the issues identified for consideration as above, as well as cluster the various lock-in co in as much of a chronological order as will be practical to determine whether the prosecution has discharged its burden to prove its case against the accused persons beyond any reasonable doubt. So the first lock-in co is Mavoko locals, where the first and the second deceased and PW1 and a colleague of PW1 had gone for the case against the second deceased, and it is from there that they were abducted as they, after leaving the court. Then we have the other lockers in Ko was Cameredo. This is where the fifth accused took the vehicle that had ferried the deceased persons to Mavoko locals. Then there was Syokimau administration camp. So the prosecution is that the 3 deceased were held at the post between midday of 23rd of June 2016 and 18:59 hours when they were removed from there and taken to Soweto open field. PW2 and 3 were the witnesses under Witness Protection Agency. They were cousins who worked at the construction site in Mlolongo area. They gave similar and corroborative evidence. They stated that on the 23rd of June, at about 1600 hours, they were coming from work together with PW2 riding a motorcycle and PW3 as his pillion passenger. On getting to the chief's camp at Syokimau, they both heard the voice of someone calling them in a low tone, which sounded more like whistling. They stated that the person was beckoning them and appeared as if he was hanging on one hand on a window grill inside a container. And because of that, none of them could fully see him. So the evidence is that he threw the note, which is the subject matter of the case, and urged the 2 of them in Kiswahili, piga hiyo namba, mwambie aje sahihi. That is, call that number and tell her to come here right away. So they stated how they rode to the nearby market so as to read the note, and the efforts that they made to reach to the wife of the second deceased, that is PW4, and the way that she reacted. She was difficult. Eventually, IJM got to know that information from the same lady, PW4, when the second deceased did not go home. So she panicked and informed IJM, and then how they swung into action. Now, an issue had been raised about the note by the defense. And also the involvement of PW6, but I have said in the case, first of all, the note was started. It was only held together by lamination, which was put by PW44 and PW45. Now, PW6, who was being objected to as having participated in the investigations, was actually an investigator with IPOA and was the initial investigating officer investigating the complaint by the second deceased, and therefore I said there was nothing untoward about his involvement in the matter, even the taking of the note from the PW2 and 3 and IJM. Now then, the note was also examined. The evidence of PW8 is on record. It confirmed that the note was written in the hand of the first deceased. The known writings of the first deceased were given together with those of the second and third deceased that IJM had, and it confirmed that it had been written in the hand of the first deceased. Now, there was also the evidence of PW4, Corporal Joseph Muchero, who visited the post on the 24th of June 2016. And he told the court that his duties were to conduct investigations upon instructions by the officer in charge, investigation branch. He says on 25th of June, he was instructed to join Chief Inspector Wino and Inspector Chemelin and conduct investigations relating to the disappearance of 3 Kenyans. He confirmed that he went to the post and carried out measurements in hand with PW39, and the conclusion was that it was possible for a socket to have been thrown through the grills of the cell at the posts, and also that there was no way somebody working at the report office could not have seen people held inside the cell at the posts. Now, the second and the third accused who were the officer in charge of duty and the officer manning the report office and the cells sentry on the day in question, that is 23rd of June, deny receiving any persons to the post on that material day. So the second accused in his unsworn defense reiterated that the post had no cell, only a report office and a store. He said that he was at the post from 12:30 hours to 1800 hours when he left from Lolongo police station until 2000 hours when he returned to the post. The third accused on her part emphasized not being at the post between 1100 hours and 12:30 hours and afterwards from 1800 hours. However, from the evidence of the crime scene officers, I find that if the prosecution establishes that the three deceased persons were taken to the cells on the 23rd of June, the third accused who was on duty as cell sentry and report office personnel saw them and therefore knew of their presence at the post. Now, Mr. Keegan for the third accused and Mr. Muchere for the fourth accused took issue with the note. I think I've already talked about the note, urging that this PW2 testified that he threw it away when the PW4 disbelieved his message. I've said the state of that note and the finding by the document examiner. I don't need to repeat. Now, the Soweto open field, now PW10 was a daughter to the registered owner of a vast 90-acre piece of land situated along Mombasa Road opposite Mastermind cell site. She stated that the place where the land is situated is popularly known as Soweto and is situated on the right side facing Mombasa direction along Mombasa Road near the Nation newspaper facilities. She stated that on the 23rd June at around 7:30, she decided to escort her visitors from her home to the road, and on the way back she said that she noticed that a stationary vehicle which had stopped on the road near the entrance to their land and had its full lights on. She further stated that the vehicle had its hazard lights on, and from a distance she was able to make out three heads of people standing outside the vehicle, but could not hear their conversation. She says she sent her brother, who was PW11, to go and investigate for her, accompanied by PW12, who was a PC Matambo, a police officer, at the Way Bridge. And what they discovered is that the people told them they were police officers and that they were on duty. Now, the other lockers in Poor was the Oldonyo Sapu, Kilimambogo. And here I said that there is no argument about this site. This is where the bodies of the deceased were flung into the river Athi past midnight, that is on the 23rd and 24th June 2016. The bodies were retrieved from the river on the 30th of June and 1st of July 2016. Then there was the technological evidence. I stated at the beginning of the judgment, there was no witness account of the murders of the three deceased. The prosecution has relied on circumstantial evidence forensic evidence, and the retracted confessions made by the fifth accused person. This evidence that the prosecution has relied upon includes technical evidence made up of phone data processed and produced by PW42 from Safaricom and 43 from Airtel. There are various call sites captured in the data involving various mobile phones. So the information required of the Safaricom and Airtel service providers was handset history, cell data, subscriber registration, and geographical location from 20th of June to 26th of June 2016. That means the information provided by PW42 and PW43 from the phone service providers to PW44 and 45 and their colleague investigators was capable of providing the history of the handset in question, showing when bought and which SIM cards had been paired with it. With the cell data, one could see the phone calls made or received through the number, as well as the time and duration of the call. It also gave details of SMSs sent or received through that line, and gave subscriber details, gave details of the person registered as the owner of the line, and if registered more than once, the details and the data of each registered owner. The geographical location gave detail of the actual location of the cell phone number or handset, and that trajectory of that record could show the movement of both the handset and the cell phone number. The only time it could not be possible to be tracked is if the phone was turned off, and this was according to the evidence of PW42 and 43. Now, as stated earlier, PW44, the Inspector Olesena, and PW45, Chief Inspector Mwangi, they were part of a team of investigating officers of this case, and the two are the ones who ultimately compiled the investigation file. Their evidence as well as their witness statements were largely similar. Now, PW44 stated that on the 19th of July, he wrote to Safaricom for the signature of PW28, and he asked for certain he was asking for data. He requested to be provided with all the numbers that were captured by the following cell site masks between 900 hours of the 23rd of June 2016 and 600 hours of 24th of June 2016, and those are Syokimau, Esa, Adriva, Kamiridu, Mastermind, and Kilimambogo. On the 4th of August, he wrote again to Airtel. He was requesting for data and subscriber details. Before I go there, PW44 stated that from the information available to him, the number 0727-433-431 was traceable at all the 5 sites that were of interest. PW44 stated that he first searched the subscriber number in all the social media platforms. Upon searching in Truecaller, the name recorded against that number was only one name, Brown. He further searched on the Facebook and found a picture and the name Peter Nguge. The picture was produced here in court as Exhibit 108. It is the very image of the 5th accused. Now, PW44 testified that on the Facebook, he found friends of Peter Nguge, some of whom were police officers at Mlolongo Police Station, and one such officer was Wilson Kamau, who testified as PW26. Now, PW44 testified that on the 4th of August 2016, he wrote to Safaricom requesting subscriber details for the number of the 5th accused, and the details showed that the number belonged to one Peter Ngoge, the fifth accused in this case, and this was the same person he recognized by the Facebook picture. On the 4th of August 2021, PW44 wrote again to Airtel requesting for other numbers. Now, one of those numbers, the number, he says that there was a number 0786-526-465 was captured at Ad River, Mastermind, Kilimambogo, Syokimau, and Thika Road, and that number was in constant communication with the number of the fifth accused, and that number 0786-526-465 was used in IMEA number, which is a long number, the two of them. Now that IMEA belonged to PW22, that is Corporal Nyakundi of Mlolongo Police Station. So PW22, Corporal Nyakundi testified that on the 23rd of June, 2016, at around 900 hours, while at Mavoko Law Courts, he was approached by one Mr. Brown. He testified that the first accused had introduced Mr. Brown to him at Mlolongo Police Station canteen on 2 occasions in the month of June 2016, saying that he was an administration police officer. He said that when Mr. Brown requested for his phone on the 23rd at Mavoko Law Courts, he could, so that he could make a call, being an acquaintance and being in a hurry, he removed his SIM card from his number 0734426104 from one of his handsets, which was Exhibit 38, and handed over the handset to Mr. Brown. He said that his mobile phone handset was a Samsung and gave the IMEA number. Now through the IMEA handset, PW44 established from the data that the number inserted when PW22 gave the phone to Mr. Brown was 0724, sorry, it was 254786307473. That number was used in the answer to communicate 15 times, 10 of the times was through SMSs, while the remaining 5 were voice calls. Of importance is that the number was in constant communication with the number of the fifth accused, as well as another number which was 0786-526-645, registered in the name of Moses Kareidi, who was PW39. Now PW39 denied that he ever had such a number. He gave his numbers to court and testified that in January 2016 he had lost his identity card number, his identity card within Mlolongo, and that he had reported the matter to Mlolongo Police Station. Now the two numbers, that is the two that were in constant communication with the number of Mr. Brown. So there was the one registered in the name of Moses Kareidi, while the other one was registered in the name of Charles Nyaberi. Of importance is that the two numbers were registered on the same day, that is one day before the murder of the deceased, that is on the 22nd of June 2016, and it was between 1800 and 18, that is between 6 and 609, meaning that it was registered 9 minutes apart from each other and registered with the same agent within Mlolongo area. So from the findings of the analysis, the fifth accused person inserted a SIM card for numbers 0786307473, and that line was in constant communication with the number of the fifth accused, and then the other number 0786-526-645. This was while the fifth accused was at Mavoko Law Courts until the 3 deceased were kidnapped and taken to the post, and also while the fifth accused drove KBX 126C to Cameredo. That means the fifth accused continued using his personal line, and therefore the two other numbers used by the others who were part of the team that executed the deceased. I have said that these two numbers are not mysterious. They must be among those, these two persons who had those two numbers are not mysterious. They must have been among those names the fifth accused has given to the court in his confession and in his own defense, without singling out for us to know which of them had that number. Now, the other line analyzed by PW44 was 0716876-388, registered in the name under Bird's Eye Auto Truck. Now, that number was fitted in the vehicle that delivered the deceased persons to Mavoko, and therefore I do not need to read any further. Now, the analysis received by the numbers received by PW44 also was for the deceased persons, and they just confirmed they were switched off immediately after the kidnap. That is what the data was showing. Now the next issue to decide, to consider, is the one of the phone data for the first and the fourth accused. Now, PW44 testified that the phone data of Frederick Leniman, the first accused herein, number 0722939198, and of Leonard Mwangi Maina, the fourth accused, herein were not spotted along the scenes of interest at the timings in question. The first accused data, exhibit 98B, shows that he was away from the geographical location of Mlolongo. Indeed, the fourth accused gave an elaborate defense of how his movement on the 22nd and 23rd, backed up by 4 witnesses. That is defense witness number 6, defense witness number 9, and number 11. So he was away from Lolongo, and those witnesses testified they were together in Ruiru and also in Thika. Now, the phone data of the first accused, exhibit 9D, showed that the first part of the day, the first accused was en route from Lolongo. However, at around 1300, that is 1 p.m., the data spots him at Mlolongo police station. At around 1351 to 1554, the phone was at Mlolongo Valley, where he was resident. At 16:35 hours, it is captured at Mlolongo. At around 1723, at Center Mombasa Road up to around 1839, and that at 1855, the first accused phone is captured at Mlolongo police station. At 2026, his phone is captured at Mlolongo Gwata, and around 2150 at Mlolongo police station, and finally Mlolongo Valley at around 2001. So the phone data of the first and the fourth accused places them away from the relevant sites where the conspirators swung into action to take the appropriate actions again, which culminated with the murder of the deceased person. In addition, as shown on the part of the fourth accused, he put forward alibi defense and called witnesses who corroborated his evidence, effectively shaking the veracity of the evidence of the fifth accused confession against him, which was the only other evidence against him. As for the first accused, there was other evidence against him, as will be shown in the judgment. Now, the phone data of the second and the third accused, Mr. Umbeta for the second accused submitted that the phone data of the second accused supported his defense of the times he was not at the post, which is the time the deceased were brought and later taken away from the post. Now, Mr. Keegan for the third accused submitted that the third accused played no role, was not mentioned in the confession of the fifth accused, and that all that her phone data established was that she was in the locations claimed, but that that did not connect her to the offenses. He also urged that PW18 in his evidence confirmed that the third accused left the post at 1830 hours. Mr. Keegan urged in the alternative that the court should consider the police pecking order and find that the third accused person, being a junior officer, had to obey orders. Now, PW 44 presented the phone data for the line 0720 388 784, registered in the name of Stephen Cheburet Mrogo, who is the second accused in this case. He testified that the phone data for the second accused, Exhibit 100B, shows that on the 23rd of June 2016, at 6:19 hours, he was at Syokimau Kiunguni, which is within the AP post. At around 8:42 hours, his phone was at Mlolongo police station. This is around the same time that the fifth accused also arrived at that station from Waidaka. At 9:24 hours, the signal locates the second accused phone at Esa at the river, which covers Mavoko locals. PW 44 say that was also the same time the fifth accused arrived at the locals premises. At around 10:40 hours to 10:48, the second accused phone is located at the river Transview, which is where the railway line, the site of the kidnapping, is located. At 11:13 and 12:01, the signal is along Mombasa Road, whereas at 12:10 it is at Caltex Depot. At 12 hours, that is 2 minutes later, is back to Syokimau AP post and remains there up to 18:49 without leaving. So the time of 12:12 is crucial because it was around the same time that the deceased persons were transported to the post and placed in the cells and kept there until the evening. So between 18:30 hours and 1900 hours, the deceased were taken from the post to Soweto open field, which was the murder scene. Now, PW 44 stated that around 18:51 hours, the second accused phone signal was recorded at Caltex Depot, and 9 minutes later at Mastermind's Mombasa Road. At around 1906, PW 44 testified that the second accused phone was captured at Mlolongo police station, where he stayed up to around 20:02 hours before going back to Mastermind, the Soweto open area, field area. At around 22:20, the second accused phone went off since no further data was collected. Now, PW4 testified that number 0719644520 was registered under Sylvia Wanjohi, who is the third accused in this case. Our phone data, Exhibit 97B, shows that on the 22nd of June 2016, she was at Mlolongo until 20:05 hours when she returned to the Syokimau AP camp. PW 44 testified that on the 23rd of June 2016, the phone data of the third accused reveals that she was within the camp or the post from 10:01 hours, that is 10:09 a.m. in the morning, to 22:31 hours. So between 22:31 hours on the 23rd of June and the morning of 24th of June 2016, there was no data generated from her phone, which meant that the phone was switched off. So PW 44 stated that it meant that the third accused was stationed at the camp throughout the day of the 23rd of June 2016 and never left the station between 10:09 hours and 20:31 hours. Now, given the circumstantial evidence adduced against the second and the third accused, what was required of them in law is an explanation to rebut the statutory presumption created by virtue of the fact their phone data placed them in all the lock-in quo as described in respect of the second accused and in the post at all the relevant time in respect of the third accused. Now, the second and the third accused do not deny that the phone numbers were theirs. That means that what happened at the post in respect of the third accused and what happened in the lock-in quo in respect of the second accused was within their knowledge, and that it was in their best interest to offer a reasonable and plausible explanation in that regard. That is what is Section 111, subsection 1 of the Evidence Act requires of them, that they have a statutory burden to give an explanation to rebut the statutory presumption created by the circumstantial evidence that they were involved in the murders. Now, the data on the phone of the second accused, who was defense witness number 1, Exhibit 100B, contradicts his testimony of where he spent the day. The second accused did not deny having his phone and using it on the 23rd of June 2016. His testimony was that he left the post at 600 hours for at the river for personal matters, which he completed doing at 950 hours. He then testified that he proceeded to City Cabanas, an area covered by Caltex Mombasa Road, Mast, where he met the second accused for purposes of viewing a cooker at Rampton Supermarket. He said that they returned to the post and that he was there from midday to 600 to 1800 hours. The third accused, in her unsworn defense, told the court that she went with the second accused person to City Cabanas on the 23rd of June. She stated that she spoke with the PW18 to hold her fort. She then said that she left for Cabanas at 1100 hours and reached there at 1130 hours. She says she returned to the post at 1230 hours, and she then said that she left the station at 1830 hours, having given the keys to the cells and the armory to PW21. She said that she was given a lift from the post at 1830 hours to Mlolongo, where she stayed until 2000 hours. Her witness, defense witness number 3, in his evidence said that he picked the third accused at the post at 1840 hours and dropped her at Mlolongo at 1910 hours. Now, the third accused, called defense witness number 4, Corporal Faith Motiso, who told the court that when she entered in the OB at the post that she had signed out of duty at 1700 hours, she did not see or she did not find the third accused at the report office. I consider the unsworn statement of the third accused. Her evidence was that she was on duty at the post those hours, 1600 and 1800, and that PW18, the one the third accused claimed she left at the post to hold her fort. In his evidence, between 1100 hours and 1230 hours, denied having received such a request from the third accused. PW18 testified that he was on duty, the duty officer at Mlolongo Police Station, and that he was leaving the post for duty at around 1230 hours when he met the second accused returning to the post. So the second accused admitted in his evidence that he met PW18 on 1 day's leave. He testified that the third accused gave him the keys to the cells and the armory between 7 and 7:30 p.m. That evidence is consistent with the third accused's phone data. The evidence of defense witness number 3, that he picked the third accused outside the post at 1640 hours, is also not correct in terms of time. For defense witness number 4, her evidence contradicts the evidence of the third accused, saying that the third accused was not at the station at 5 p.m. Now, the prosecution has shown that the second accused was present at all the lock-in quo except for Kilimambogo. That is, that he was at Mavoko Law Courts when the 3 deceased persons attended court, that he was at the railway line where the 3 were kidnapped at the time that it happened, that he arrived at Syokimau police post at the time when the 3 deceased were placed in the cells, and that the second accused was at Soweto open field where the deceased were murdered at the time that the murder was committed. Now, for the third accused, the prosecution has established that she was on duty as the report office personnel and the cell sentry when the 3 deceased were taken to the post. She had the responsibility over the key to the cells. Therefore, she must have opened the door for the deceased to be placed in the cells. She remained at the post from 10:09 in the morning up to 2000 hours in the evening, which period covered the time that the deceased were taken to the post to the time that they were removed from the post. I'm satisfied that the phone data of the second and the third accused was the true record of their movement and location on the whole of the 23rd of June 2016. That data clearly shows that the two played a part in the murder of the deceased. Now the issue is whether the prosecution has established that the accused persons were principal offenders, acted with one common concert or intentional consent to commit the offense, and whether the circumstantial evidence adduced was sufficient to lead to a conclusion that the accused persons murdered the deceased persons. Now, I have begun with a quotation from a treatise of Samuel March Phillips, which I do not intend to read. Maybe I'll read a little bit so that you can hear what it is saying. It is a treatise on the law of evidence, 1824, 4th edition, page 96 to 100, which opines, and I quote just in part, "It is an established rule that where several persons are proved to have combined together for the same illegal purpose, any act done by one of the party in pursuance of the original concerted plan and with the reference to the common object is in the contemplation of law, the act of the whole party, and therefore the proof of such act will be evidence against any of the other who were engaged in the same general conspiracy, without regard to the question where the prisoner is proved to have been concerned in the particular transaction." Now, Mr. Keegan submitted that due to the pecking order and that due to the junior rank of the third accused, she had no choice but to obey. He submitted that the third accused data shows that she did not communicate with the co-accused or the deceased and was not at any of the sites which was the scene of murder, and he relied on a case which is quoted there. He also urged that malice aforethought, as prescribed by Section 206 of the Penal Code, altogether is also incoherent. He urged that the second ingredient of murder, that is actus reus, was also not proved, that there was no evidence adduced to show that the third accused had anything to do with the murder of the deceased. Now, the prosecution proved that the third accused was at the post between 10:09 and 1900 hours, and that due to the opening between the cells and the report office at the post, the third accused must have seen the deceased in the cells. It was established that she was the sole officer on duty at the post. Thus, she was the responsible for the key to the cells and had custody of the station. Now, the submission by Mr. Ombeta and Mr. Keegan for the second and third accused, respectively, that the phone data of their clients were in line with their defense is not accurate. Their defense was in direct contradiction with their phone data, as shown here. The alibi defense the two put forth as their defense was totally displaced, as the second accused phone data captured him at all the lock-in quo, and where the crime sites were located at the very relevant times that the events in question took place. The only place that the second accused was not located is the journey from Soweto open field to the Kilimambogo area. That means that the second accused was involved in the entire execution phase of the murder of the deceased, from the time that he proceeded to Mavoko Law Courts all the way to the time that he proceeded to Soweto open fields and remained there until 8 p.m. when he switched off his phone. Now, for the third accused, she was at the Syokimau post continuously the entire day from 10:09 a.m. to past 7 p.m., which are the times the deceased were placed in the cells and later collected for the murder site. Now, Chapter 5 of the Penal Code is titled Parties to Offences, and Section 20 deals with the principal offenders. Now, in my considered view, given the fact that the third accused was the police officer manning the OB desk and also had the keys to the cells, where there was no entry in the occurrence book or in the cells entry, or in the cells made to indicate that the deceased persons were held at the station, she was a principal offender. There is no way that the deceased would have entered the cells without her releasing the key to open it. She could not feign ignorance of the fact that the deceased persons were in the cells, as from the evidence of PW14 and PW39, her desk in the report office was at par with the opening between the report office and the cells. She was on duty continuously from 10:09 a.m. To 7:30 p.m. and present at the post all that time as per her phone data. Being a police officer, the third accused knew the importance of keeping proper and up-to-date records at the post. It ought to have occurred to her that there was an illegal and wrongful intention to secretly detain the deceased at the post the moment no entry was made in the OB. So the third accused is a principal offender within the meaning of Section 21B and C of the Penal Code, and her position is similar to the ones who actually committed the murder against the three deceased. If the third accused had dissociated herself from the other co-accused by some action in order to show that she was not with them in the offense, then her role would have been different. However, she did not dissociate herself from the others. What she did was to deny knowledge of the incident. That does not exonerate her of these offenses. Now, I've considered that an accused person has a right to refuse to give self-incriminating evidence as set out under Article 52(1) of the Constitution. As a general rule, the burden of proof in criminal cases rests with the prosecution, and this is also as provided under Section 107 of the Evidence Act, which states that whoever desires a court to give judgment as to any legal right or liability dependent on the existence of facts which he asserts must prove that those facts exist. Now, if it then follows that if an accused person chooses to hide some facts in order to protect others in court or at large, such an accused cannot be compelled to give such facts, since the burden lies with the prosecution to bring out such facts. The burden only shifts to the accused person under circumstances bringing into operation the provisions of Section 1111 and 119 of the Evidence Act. In this case, the burden shifted to the third accused to explain how the deceased were held at the post while she was on duty without any entry in the OB, how they were placed in the cells and later removed while she had custody of the keys to the cells. Instead of explaining these facts, the third accused decided to deny and also to mislead, feigning ignorance that the deceased were never there, as well as trying to escape culpability by implicating PWA 18 and 2021 as the ones with the keys at the time the deceased were taken to and removed from the post respectively. Even where the role played by the third accused was that of aiding and abetting, except for the change of terminology, at the end of the day, she is still a principal offender under Section 21B and C of the Penal Code. As for Mr. Gigan's submission that in regard to the pecking order, to obey orders to commit an offense is not a defense, certainly not to murder. It cannot be a defense available to the third accused. In the circumstances of the case, her role was critical, as it was possible for her to thwart the bad intentions of her co-accused just by entering in the OB, the placing of the deceased in the cells, and it was her responsibility to enter the OB if the ones who were expected to do so failed, as she was the one manning the post at the time. Now, for the second accused and the fifth accused, they were principal offenders by virtue of Section 21A, which provides that every person who actually does the act or makes the omission which constitutes the offense, the two of them took an active role in the kidnapping of the deceased, concealing their missing vehicle, detaining them without disclosure, ferrying them to the murder scene, and ferrying them around for each of these purposes. Now, the fifth accused in his statement stated that when they drove the deceased to Soweto open field, the co-conspirators argued for 3 hours whether to kill the deceased or not before they finally took their lives. The fact that they argued, then resolved to continue with their planned intention to take life, does not reduce their actions to anything less than murder. They had a common intention within the meaning of Section 21 of the Penal Code, and I've quoted what it says. So for the second, third, and fifth accused persons, I am satisfied beyond any reasonable doubt that the prosecution has established that the accused persons were principal offenders. They acted with one common intention to commit the offenses charged as explained herein above. The evidence adduced by the prosecution against these three accused, which was largely circumstantial evidence, was sufficient to lead to a conclusion that the accused persons murdered the deceased persons. As to the alibi defense, the second and third accused person put forward, I am satisfied that as to the alibi defense, the second and third accused put forward, I am satisfied that it has not shaken the prosecution evidence that was adduced against them. Now, the other consideration is on the trajectory. This was PW37 was an officer based at the IC3, the Inspector General's Office, Jogoo House, Nairobi. He testified that the IC3 is a center where all the 99 and 112 emergency numbers are received. He testified that the radio exhibit 25 was designed to give a location of its whereabouts. So he was given a request, which he said he now executed. He did a trajectory of the vehicles, which includes the vehicle that was carrying the deceased persons. And that I've already dealt with that, so I'll not go into that. Now, he testified that the investigating officers were also concerned to know whether any police radio phone registered activity within Mavoko locals, particularly in the hours of 1200 hours on 23rd of June 2016. And one radio fitted that description, which was the radio with ICDA number 359033304, which is Exhibit 25. Now, PW37 stated that on further query of the serial number, it indicated that the radio phone was captured at Syokimau Police Post at 12:20 hours to 12:40 hours. The radio phone was captured at Mlolongo Police Station between 15:20 hours and 15:40. The radio phone was later captured again at 18:40 hours, between 18:40 hours and 1900 hours at Syokimau Police Post. The radio was captured at isolated field mastermind area called Soweto between 1940 hours and 2000 hours. At around midnight, the radio is captured on the Eastern Bypass, traveling towards Kangundo Road. It was again captured at Thika Superhighway at 0040 hours, between 0040 hours and 1 o'clock on the 24th of June. This is the same night. And then finally on the 24th, the radio was captured at Valley View Estate between 22:20 hours and 22:40 hours. That radio phone, Exhibit 25, according to PW20, the OCS Mlolongo, was IMEA number 864106020019873 and was issued to the in charge SPIV, Senior Sergeant Lediman, who is the first accused in this case. PW20 testified that every radio has its own charger and that every office had a charger. PW20 testified that he issued the first accused with the radio Exhibit 25, which he received together with its charger. The first accused stated that upon deployment from Athi River Sub-County Headquarters in Mlolongo Police Station, following his transfer from Turkana to the region, his boss, who was defense witness number 10, Commissioner of Police, issued him with a firearm, a bulletproof jacket, and a radio phone. The first accused gave its number as police number 559030101 and the IMEA number 864106020311076 and was exhibit that 5. Now the first accused stated that it was that radio phone that is he and his SPIV team used for their work. He explained that he could not have given this radio phone to anyone else except Sergeant Mwangi, as the other officers were from the regular police, that since the fourth accused was proceeding on short leave, he went home with the radio. That on the 23rd of June 2016, the radio was at home. And that on the 24th June 2016, he left the radio charging at Mlolongo Police Station, Crime Office, when upon switching it on, in the morning of 24th, he realized that it had no charge. Mr. Ombeta submitted that the police should have investigated the alibi of defense of the accused, given it was put forward early enough. For that proposition, he relied on a Nigerian case, and then he also he relied on the Kenyan case Wangombe versus Republic for the proposition that a prisoner who puts forward an alibi as an answer to a charge does not thereby assume any burden of proving that answer. It is misdirection to refer any burden as resting on the prisoner. In such a case, for the burden of proving his guilt remains throughout on the prosecution. Now, the prosecution has established that on 1st July 2016, when the first accused was arrested, he had the radio phone, which is Exhibit 25. He also acknowledged in his defense evidence that he was actually arrested with that radio phone. As shown above in the evidence of that PW-7, this radio phone, that is Exhibit 25, was captured in all the sites at the various stages in the sequel of the commission of the murders. It was at the posts at Syokimau, post at 12:20 to 12:40, when the deceased persons were delivered there and placed in the cells. It was captured again between 1840 and 1900 at the Syokimau post, the time the deceased persons were removed from the cells for Soweto open field. The radio was captured again between 1940 and 2000 hours at Soweto open field, where the murders took place. At around midnight, it was captured on the eastern bypass traveling towards Kangundo. The radio was captured at the Thika Superhighway at 040 hours, which is the time of the return trip from Oldonyo Sapuk. PW-7 testified that the phone radio signals could be tracked within Nairobi area and towards Thika. The signal tracking ends around Juja, which explains the lack of tracking beyond Juja, both for the trip towards and trip from Kilimambogo. Now, under Section 111, subsection 1 of the Evidence Act, the first accused to discharge a rebuttable presumption by offering a reasonable explanation about the radio phone Exhibit 29, which was tracked in all the lock-in quo, and 9 days later was actually found with him. I have considered the sworn testimony of the first accused. He stated that upon deployment from Athi River Sub-County towards Mlolongo area police station, following his transfer from Turkana, His boss, who was PW10, issued him with a firearm, bulletproof jacket, and a radio phone. Now, the first accused gave its number as police number 55903101 and a mayor, which is exhibit 35. Now, the first accused stated that it was that radio phone that he and his PIF team used for their work. He explained that he could not have given this phone, radio phone, to anyone else except Sergeant Mwangi, as the other officers were from regular police. That since the fourth accused was proceeding on short leave, he went home with the phone. That on the 23rd, it was at his home. That on the 24th of June 2016, he left the radio phone charging at Mlolongo Police Station Crime Office. When upon switching it on, he found that it had no charge. That is on the morning of 24th. The first accused was arrested on the 1st of July, carrying the phone exhibit 25. When asked how come he had it, yet his evidence was that it was never used of the 4th, and that he proceeded to Makindu police station, but on the return he could not find it, so he grabbed the one that he found charging, which happened to be exhibit 25. Now, what the first accused needed to give was a plausible and reasonable explanation of how he came to be found with P exhibit 25, which had been to all the lock and quo of this case, and yet he insisted the radio phone was not the one that had been issued to his team. His explanation is incredible for reasons. One, PW34, the county commissioner, the county communications officer in Machakos, testified that on the 26th of April 2016, he issued new pocket phones to the River Division, which was to start using the new system of radios covering Nairobi area. His PW34 testified that he indicated who should receive which specific radios. In Mlolongo, he said the specific pocket phones that each officer, that is the OCS, his deputy, and his PIF team, and the CID section, and Syokimau police post were to be issued with, as per his register, which was exhibit 73A. 2. PW20, the OCS Mlolongo, confirmed that the first accused received the radio allocated to PIF team, which was exhibit 25. And then 3, the radio exhibit 36 had no data, and PW37 testified that the reason for no data was because it was never used at any one time. Indeed, PW44 and 45 and other team and their team recovered it. At the time that they recovered it, it was in the house of the fourth accused. The radio was neatly packed in its box, complete with its wrappings and the nylon film used to protect the screen when it is new. It is therefore not true that the first accused, what the first accused said, that he and his PIF team used that gadget for their work. Now, 4, after being in each of the 5 sites or lock and quo of the murders, the radio, which is exhibit 25, was captured at Valley View Estate between 22:20 and 22:40 hours on the night of 23rd and 24th June 2016. Now, Valley View Estate is where the first accused, the house of the first accused was. So where he lived with his family at the time. And then 5, the first accused was carrying the radio, exhibit 25, on the 1st of July 2016, when he was arrested at Flying Squad offices where he had been summoned. And lastly, since the first accused said that he was the one who had the radio, exhibit 36, on the morning of 24th of June 2016, when he left it charging in the office, how did it get to the house of the fourth accused? In its box, wrapped as new, complete with the protective film on the screen, and yet the fourth accused was away between the night of 22nd of June And the 27th of June 2016, how did it get to the house of the fourth accused? Now, the evidence of the police radio phone trajectory detailing the movement of the radio P Exhibit 25 on the 23rd of June and the evidence of its recovery from the first accused 9 days later all show that the first accused, as in charge of SPIV and in line with the accountability protocol of accountable gadgets like police radio phones, had custody of the radio phone and had used it exclusively at all the 5 lock-in quo at the time the offenses were committed. The prosecution proved that the radio issued to the first accused by defense witness number 10 was never put to use. So I find that as the radio indicated, the first accused was at the Mlolongo police station on the 23rd of June 2016. He proceeded to Mavoko locals, then to Syokimau post, to Soweto later that evening, where the deceased were all murdered, and to Klimambogo through the Kasupa highway to dump the bodies of the 3 deceased persons before returning to fetch his co-accused at his bar in Mlolongo for work well done. Now, I consider the first accused defense, the evidence of his witnesses. I find that the prosecution has established that it is the first accused who had the motive to harm the second deceased in this case, because as a result of the complaint he made against him at IPOA, his job was on the line. The first accused may have gone to Uhuru Camp to help his sister-in-law in the morning of the 23rd. However, from then on, the evidence is overwhelming that he personally attended to ensure that the deceased persons were captured, they were detained to await nightfall, they were murdered, and their bodies dumped or flung into the river to make it difficult to ever recover them. His explanation about the radio phone Exhibit 25, just as his alibi defense, is unreasonable, incredible, and is not plausible, and therefore I reject it in total. I have carefully considered the entire evidence adduced in this case by both sides, and I have considered the submissions by counsel the authorities relied upon. And having done so, I find that the circumstantial evidence established against the first, second, third, and fifth accused persons justify the drawing of an inference of guilt to the exclusion of any other reasonable hypothesis except that of guilt. I considered whether there were coexisting circumstances that could weaken the chain of the circumstances relied upon, and found none. I am satisfied that there was no other reasonable hypothesis that can be made on the basis of the evidence before me except that of guilt. In the result, I find that for the fourth accused, his alibi defense has shaken the veracity of the evidence of the prosecution against him, being that of the fifth accused alone, and therefore I gave him the benefit of the doubt and acquit him of all the 3 counts of murder under Section 322 of the Criminal Procedure Code. For the first, second, third, and fifth accused, I am satisfied the prosecution has proved the case against them beyond any reasonable doubt, and therefore I found them guilty of the 3 counts of murder, contrary to Section 203 of the Penal Code. I accordingly reject their defenses, find them guilty as charged, and convict them accordingly under Section 322 of the Criminal Procedure Code. Now, I also want to inform the first, second, third, and the fifth accused persons that they have a right of appeal within 14 days from today. And before I end, 2 things. I wish to register my gratitude to the Learned Prosecution Counsel, the Learned Counsels for the defense, and the Learned Counsels for the victims and the interested parties. And I thank you very much for your great support, your industry, and contribution to jurisprudence and also for giving me an opportunity to complete this case. And I also thank the accused persons for allowing me to complete the case. At the beginning, it didn't look like it was going to happen. Now, I wish to end with a little story. There is a man who told his son that he wanted to teach him a new trade, so he asked him to follow him. They went to the neighbor's farm and stood next to a mango tree. The father told the son to look around as he climbed up to pluck some mangoes. He told him that his role was to look around, and if he saw anyone at all, to start running home, and his father would follow him to avoid arrest. So the young old man climbed the tree. After 5 or so minutes, the father saw his son running, so he climbed down quickly and followed him. After running for some time and seeing no one following them, the father stopped his son and asked him why he ran, telling him that he did not follow his instructions. So the son said, "No, but I did follow your instructions. I looked up and I saw God looking down on us, so I ran away." So that is the end. No.
Sorry, let me show issue. Before sentencing, we should be on record.
Now I'm totally funked as official. I want to make only one order. To take this, to have this file placed before the presiding judge criminal, so that you proceed with the other things. What did you want to say?
Obviously, before the sentencing, we wanted to inform the court that the 4 accused persons are first offenders.
No.
But we'll do it before the other court.
Not even that. I think we also need to have victim statements,
yes,
victim impact statements and things like that.
Most of those. And of course, we wanted to request whether there can be also probation of charges before the sentencing.
Tell them to stand.
Ladyship, we request we have an issue that you've raised. Your Ladyship has said that your predisposition is that the other aspects, including sentencing, should go probably to another judge. On behalf of the third accused, your Ladyship, we would have preferred that you complete the process. Yes, we want to be on record as saying that, your Ladyship.
I thought you said I'm coram non judice.
I think I'll be taking the same position with my colleague, because again, also having had your judgment and another judge coming in to give the sentence, putting into consideration that you said the second accused person gave unsworn evidence, yet we know clearly that he gave sworn evidence. How would that be handled? He gave sworn evidence, he was cross-examined. In your ruling, the whole judgment is that he gave an unsworn statement. From this particular point onwards, you can see why we want to appeal and why we're having a problem with your judgment.
I don't know what you are saying. What are you saying? Are you saying I hear this, I do the sentence, or are you saying...
Yes, you let us go to the end, because you see, the moment you have said that my client gave unsworn evidence, yet we all know that he gave sworn evidence and was cross-examined. That puts us in a position whereby, first of all, we are saying that probably the new judge who comes in to do the sentencing must look at You having then given the judgment, with this very serious omission or problem that you have created, do you shift this burden to another judge, or do you do it by yourself? Because for me, it is pretty serious that you did then not get the evidence of a second accused person you have convicted him, yet he gave sworn evidence. It was cross-examined by everybody, but according to your record, it was unsworn. How did this come about? So these are issues that we will raise, probably maybe even in the next judge, but I'd rather that you are there so that we can throw these rocks at you.
Your Ladyship, the whole idea was mine. I just want to dissociate myself from what Cliff has said, Your Ladyship. Your Ladyship, my point is this, Your Ladyship. I'm not taking the same militant position as Cliff is taking. My point is this, Your Ladyship. Sentencing is the point at which a judge is most subjective. It is the point at which the judge is applying consideration of all the issues that are obtained since the start of the case. And for that reason, Your Ladyship, if there was any role you would have played, it is more at sentencing than at any other point. And for that reason, Your Ladyship, I'm making more informal request, Your Ladyship, that you do, having come this far, that you do entertain the process up to the point of sentencing.
No, but somebody wants to throw things at me, so why do I want to sit around to wait for missiles to be thrown?
But who else can do that? You see?
Now I think, let's hear Mr. Michuki.
Yes, because even when you place the radio in the second accused's hands and you read it in your judgment, we have a problem, don't we?
Your Ladyship, just 2 points. First, I'd like to associate myself with my senior, Mr. Carter. I think sentencing is an exercise of discretion, which you have to take a number of factors in. A new judge does not have a grasp of this matter to really sentence the accused persons or not the convicted persons. Secondly, my lady regards to seek your indulgence that he continues being held at Naivasha under the protective circumstances. He has been held since he took play in this matter. Yes, separating from the other accused persons has always been the case. Lastly, off the record, given that my remuneration falls squarely upon you, my lady, I would wish for you to proceed.
I thought you are the one who is very sure I'm coram non judice.
Your lady, you already assumed jurisdiction. I will follow you. I'll follow your decision. We cannot give any other issues on appeal.
Your Ladyship, on behalf of the court accused, we can only say thank you. It has been a long journey.
My lady, on behalf of MYKE and of course the victims, sorry, Mr. Chair.
Yes, on behalf of the court accused, we are also requesting that his mobile phone unit has been found, be restored to him. And also, on behalf of the first accused, only for Plan and Council, Mr. Cliff, on better, is requesting that his car be released.
Whose car?
The first accused car.
There was not a vehicle that that was used as an exhibit that was detained. We have that argument, and the state had said that they wanted to vote on it. You had made a decision that you would, at the end of the trial, make a decision about it. There was not a record that was used as an exhibit. It was KP 959 something. Yeah. It's so long we have not forgotten about it. But it's in the court.
I don't know what I'm releasing. Does it have an exhibit number?
I know it's a KBF 959H. It was a Winroad Nissan. KCG 959H. It was a Nissan Winroad white in color. No, second color.
That's not the one you released to the wife of the first accused. It's not the one.
Nothing was released.
K what?
KCG 959H.
Yes. Anyone else?
Really, on behalf of the victims in their entirety,
Yes, just 1 minute. Just 1
the
minute.
family and their wife,
Yes, we would also wish to file a victim impact assessment, 29C of the CPC, and we are seeking 14 days and we are doing this victims in their entirety.
So when you say law society, how many statements am I going to get? Or will be filed? You are saying the entire law society, so I don't know how many statements.
Let me just 2 statements, but covering the victims in their what has been from the LSK and victims in terms of the family. And related to this. And then before we go to the last part, people wanted to say something before we also discuss our process. Things or something technical to deal with. My name, I think when first I stood, I was not sure before I completed my statement.
Yeah, because I wanted to adjourn, but other people have now said other things.
Yes, now that we proceeded, allow me to say this. First of all, that the 4 accused persons, 1, 2, 3, and the 5th, we have no previous records of conviction.
We are not taking any mitigation at this stage.
Okay, I'll say that later. Then, really, my view is that a court that convicts is the most appropriate sentence. And we require 2 weeks to have the statement. That is the impact statement. We have filed only 3 in relation to the deceased persons. Put in place for your consideration. We also urge you to exercise your discretion and order for professional class report in respect of the 4 accused persons to be filed and shared with the prosecution before the sentence is closed. These are our two prayers. The initial had been raised by a motor vehicle, which was produced by the prosecution, which belonged to the spouse of the first accused. And the motor vehicle that was used to ferry the deceased person's bodies to the lady. We have not come to the conclusion of this matter. We only have a conviction, and it will be premature. My understanding and the interpretation of the law to come to this matter now. But when we come to it, we want to address ourselves substantially, because as you indicated when there was an attempt with the use of the motor vehicle, we did indicate that this was an instrument of crime which is subject to forfeiture, which are auxiliary orders of court. So I want to go into it.
You're saying subject of what?
Forfeiture. And I don't want to go into this because we want, after the conclusion of this matter, to address the issue of substance where we had. And if need be, we file our submissions in the matter, in respect of the release. That is all.
My lady, in this motor vehicle, we had a problem about it. Initially, at the close of the prosecution case, and then after the defense case, and now a creation is being made that is subject to forfeiture. That does not exist on any law.
No, I'm not.
My lady, the only thing that exists on forfeiture is known. It's either things to do with drugs and lots of. In murder cases, let him not create this law. It's not there. Let him just release motor vehicle. I don't know what interest they have on this motor vehicle on the 3 stages that were made this application. It does not exist. If it does not exist, then your leadership can't even give him time to make an application about it. It doesn't exist.
No, I'll not consider that one for now. I think if their indication is they want to make submissions, then we can hear, but both sides can be heard. Yes.
Your Leadership, I just wanted to seek a copy of the judgment of the court for now. To go on record that we get it to hold. Your Leadership, you know, and the proceedings certified for purposes of appeal.
The proceedings are there. I thought you have been getting all of them.
They're not certified, Your Leadership.
Now I'm funked as official. You will talk to the DR. So is this?
Your Ladyship, we have a request also for the third accused. Your Ladyship, in view of what the prosecution has said and the victims, Your Ladyship, we would pray that the victim impact reports, Your Ladyship, be designed in a way to make reference to specific accused persons, Your Ladyship, rather than general contention on the part of the victims, Your Ladyship. And we still plead with you not to step out, Your Ladyship.
No, I think I've had enough. I should just step out of this matter. Don't you think? Now, do you want to give a written mitigation?
For the first person, I prefer that I do it orally.
For the third, your leadership, we propose to write it in writing, and your leadership, we would like clarification whether our 14 days start running today or after you do the sentence.
Your leadership will also do as elected, but we will seek to do a mitigation post-service of the written reports and the pre-sentencing report. Yes. Secondly, on the issue of the appeal, I think maybe I can use that to seek to ask you to continue sitting in this matter. We might have a situation where there's an issue with the sentencing, we have to go out to appeal, one on conviction, one on sentence. Maybe.
There's nothing like that.
That is the situation we'll be creating. We'll be creating new jurisprudence.
Now, the vacation is coming, so I don't think anybody will be able to sit during vacation. Can you take 23rd of September for the mention?
Accepted. maybe by accident it should be following.
That I'm not based in Nairobi, so if I'm not facilitated, I'm not coming back. So the orders are that the case is adjourned and with the following orders. So the first, second, third, and fifth accused persons will remain in custody pending the sentence in their respective prisons. There will be probation officer's report on the accused persons. That is the ones who have been convicted, and there will also be a victim impact statements, limited to 5 because we want from the victims, the deceased, and then maybe the other victims, only 2 others. And this report should be shared across the board. And then the case will be mentioned for receipt of those reports and also for further directions on 23rd of September 2022.
Already, on behalf of the bar, the Law Society and all the council present.
Just identify yourself for the record.
Yes, my name is Eric Theory, President of the Law Society of Kenya. I wish to place on record the gratitude of the Law Society and its members to the court, to the prosecution counsel, to the defense counsel, to the victims counsels, and particularly to counsel representing the Law Society, Professor Siganya, Mr. Ongaro, for the industry in which they have represented their respective clients before this court, and for the manner conducted the proceedings. With Kimani was a crusader against police abuse of authority, and he unfortunately, in the course of our crusade, and it is largely due to the work of his fellow crusaders that today this court has delivered a very significant judgment and really the significance of this judgment is a demonstration of the triumph of justice over impunity, and it reinforces our belief in the administration of justice and the rule of law. But the decision is also significant in the fact that it cements the place of use of technology in investigating and prosecuting criminal suspects.
today this court has struck a bold strike for the rule of law in the administration of justice. And I really thank you for that. Finally, before I seek my remedy, allow me to recognize the family of Willy Kimani and his two other deceased, Joseph Mwena and Joseph Willy. Already the family has consistently attended this trial, except perhaps during the COVID period. They have demonstrated in their coming to this court every day their utmost belief in the ideals for which Willy Kimani died for. And I want to commend them for their bravery, for their fortitude, and to say to them that Willy Kimani did not die in vain. And this judgment is a testament to that. And all the members of the Law Society reinforce the creed that they have always made. I am Willy. Thank you very much.
I think with that I say thank you very much. I can see we had an overflowing crowd. I wish you all the best. Whether I come back to the case or not, I wish you all the best. And the court is adjourned. Hii ndio